to talk about LCA compliance issues, avoiding DOL penalties. LCA compliance issues, challenges, and sanctions. The Department of Labor, DOL, has established a process for handling complaints concerning the failure to meet the conditions of a labor condition application, the LCA, or of making misrepresentations. Sanctions include back pay, civil fines, and disqualification from USCIS approval of employment-based immigrant petitions, or H, L, O, and P non-immigrant petitions. These sanctions have been increased by the American Competitiveness and Workforce Improvement Acts of 1998, or ACWIA, ACWIA, and the implementing regulations. DOL penalties for LCA violations. ACWIA increased the fines for LCA violations, including 1. A $1,000 fine and 1-year prohibition from filing immigrant and non-immigrant visa petitions for failure to meet strike or layoff attestation, a substantial failure to meet working condition attestation or displacement attestation, posting or recruitment attestation, or misrepresentation of a material fact in the labor condition application. Second, a $5,000 fine and 2-year prohibition from filing immigrant and non-immigrant petitions for a willful failure to meet any attestation or willful misrepresentation of a material fact in the LCA. Third, a $35,000 fine and 3-year prohibition for a willful failure to meet an attestation condition or a willful misrepresentation of a material fact on the LCA, in the course of which failure or misrepresentation a U.S. worker is displaced during the 90 days before filing or through the 90 days after filing the attestation or petition. In addition to fines and prohibitions, willful violators may be randomly investigated for 5 years. Additional LCA violations for which penalties may be imposed. These include the whistleblower. Protected by the whistleblower provisions are employees, former employees, and applicants who cooperate in a proceeding or investigation concerning the employer's compliance with the LCA requirements. The employer violates the whistleblower provision by intimidating, threatening, restraining, coercing, blacklisting, discharging, or in any other manner discriminating against a whistleblower. Violations of the whistleblower provision may be fined up to $5,000 and prohibited from filing petitions for 2 years. Another new penalty applies when the employer requires the H-1B non-immigrant to pay a penalty to the employer for leaving the job prior to the contracted date. The employer may be fined $1,000 for requiring an H-1B worker to pay such a penalty, and may be required to return the amount paid to the H-1B non-immigrant, unless the amount is purely liquidated damages. Bench time. An employer is in violation of the labor condition application requirement for placing an H-1B non-immigrant in unpaid, non-productive status due to a decision by the employer based upon factors such as lack of work or due to the H-1B non-immigrant's lack of permit or license. A violation will be found for failure to pay full-time wages to a full-time employee, failure to pay a part-time employee the part-time rate identified in the visa petition, failure to pay a new H-1B employee within 30 days of admission, or failure to pay a new H-1B non-immigrant already present in the U.S. within 60 days of the date the non-immigrant becomes eligible to work for the employer. The prohibition against unpaid non-productive status does not apply to non-productive time due to non-work-related factors, such as a voluntary request by the non-immigrant for an absence, like maternity leave or circumstances rendering the non-immigrant unable to work. Let's look at a scenario now of how these new LCA rules have affected the H-1B filing practices of many employers. We will use Company A consulting company, as an example. Company A used to file all applications for H-1B employees as full-time, 40 hours per week, even though they did not always have work for their consultants. They did not worry about this because they would just bench employees that did not have work. With the change in the rules, Company A has to continue to pay those benched employees based on the hours listed on the LCA and the I-129. Since Company A did not want to continue to pay full-time wages to benched employees, they started listing the hours as 20 to 40 hours per week. Now when Company A benches an employee, they are only required to pay the lowest end of the number of hours, i.e. 20 hours per week. Some companies push this even farther, listing the hours per week as low as 10 to 40 hours so they can pay benched employees even less. Liability in case of placement. Another LCA compliance issue will occur and new penalty will be incurred if the petitioning employer places a non-exempt H-1B non-immigrant with another employer and that other employer did or does displace a U.S. worker during the prescribed period of 90 days prior to filing the LCA through 90 days after filing the visa petition. A fine of $1,000 may be leveled against the placing employer if the employer knew or should have known of the displacement, or the employer has been subject to sanction based upon a previous H-1B placement with the same other employer. The petitioning employer may be prohibited from filing a non-immigrant or immigrant visa petition for 1 year. The days of the H-1B employer being able to avoid penalties by just saying, "I didn't know," are gone. In the past, consulting companies didn't care and simply wouldn't ask the questions to find out if U.S. workers were being displaced by their consultants. Now, failure to ask can net the placing employer at a minimum a fine and possible debarment for 1 year, as many employers have found out. Conclusion. With the labor condition application investigations by the DOL on the rise, VisaPro performs audits of LCA compliance programs and public access files, assisting corporates to evidence their good faith effort to comply with all regulations. Combining our legal knowledge of the H-1B and LCA regulations with our experience representing companies through LCA investigations, VisaPro provides clients with the tools necessary to run a successful H-1B program, including the preparation of public access files.